The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of April 20, 2025, the podcast that shot Liberty Valance. This is your host, Shane Killian. Let's basify the news of the bogus. And the big story this week is the major hack of 4chan, the anonymous image messaging board responsible for so much epic trolling over the years, including Pepe the Frog, Kekistan, Rage Comics, Wojaks, and even the hacker group Anonymous. And of course, who could forget Bodie McBoatface? There's just something weird about a site that has more drama stirred up over StarCraft than politics. Anyway, the competing Soyjak Party forum, which apparently consists of users that got kicked off of 4chan and decided to create their own image-sharing site with blackjack and hookers, gleefully celebrated what they called Operation Soyclips, where not only source code and databases from the site were exposed, but also personal data about the site's admins. As of the podcast prep, the site has been down for 4 days, and no one knows when it'll get back up online, if it ever does. One of the 4chan janitors, which is their word for moderators with lesser admin powers such as deleting messages and threads, said, quote, "I'm somewhat taken back. 4chan's moderation team has had leaks in the past, but this is obviously an issue of greater magnitude. I'm not happy about the situation. I'm sure most others aren't either. But many of us have been doing this for a long time. Doxing is a long-standing pastime on 4chan, and the possibility that we could be exposed has always been there. It's bad when you think of all the people who posted and moderated under the color of anonymity. Although most users are probably pretty safe having not given the site any of their data, people who actually created user accounts with personal data could find all of that has been leaked. And if nothing else, there's always certain information sites always get, such as IP addresses. Apparently, the hackers have been in the system preparing this for a long time. No one quite knows how long or how much of it was an inside job. What we do know is that the site was about as insecure as you could make it. It was running on FreeBSD 10.1 that hadn't had any updates in a decade. And once the source code got out, people realized it was using an out-of-date version of PHP as well. And the collective knowledge of the internet went through and found just tons of exploits right there in the source code. In fact, it makes you wonder how the site lasted this long without being hacked a long time ago. They also released all of the tables for the MySQL backend, and yes, I'm pronouncing it SQL, not SQL, so just deal, which show interesting stats like 10.7 million banned users, which is interesting on a site that is both anonymous and allows all sorts of terrible things on there, including overt racism and calls for violence. And so you have to wonder what one actually has to do to get banned. But apparently, 10 million people found where that line was drawn and stepped right over it. There are also about 200,000 blacklisted sites. The MySQL database was accessed with the very popular PHP MyAdmin tool, which is frequently patched for vulns because its ubiquity makes it a juicy target for hackers. What's also interesting is how many people on the moderation team had emails with .edu addresses. Yes, students, faculty, even professors at universities like Harvey Mudd, the University of Washington, and the University of Michigan were all 4chan moderators. At least one of them is confirmed to be a professor, and there are also some pretty high-up executives at a few companies. Pro tip, if you're going to be moderating a notoriously edgy and extreme message board, there are free emails you can get. You don't have to use your work email or your university email. Now, one thing to point out, because there's speculation, there were no .gov emails or emails associated with other governments or government contractors. Of course, that doesn't mean there were no government agents on the board. It just means they were smart enough to make a Proton Mail account. Which is another thing. You'd think there'd be a lot of Proton Mail accounts or throwaway mail accounts, but no, over half of them were Gmail accounts, and there were also a large number of Outlook.com accounts. Also, another pro tip, if you're going to be laughing when other sites are compromised or even causing the compromises yourself, make sure you're on a site that hasn't neglected to install updates in years. There's really not much more to say until more information comes out. We'll have to see if the hackers are any more forthcoming, I guess. Until then, the other big question is 4chan ever coming back? Because there's just nothing else on the internet like it. Well, except for 8kun, Shardy, Enchan.
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. The Orange Overlord.
Oh, my ear!
Bernie Slanders. Debate Dominator.
My kippa's ruined.
Or Joe Sleepy.
Build me back.
And of course, Mr. Fancy Pants himself.
Forget those losers! You can get the Gold Edition and play as 4 more characters, including me, the Spooky Spaceman, along with Billionaire Brat, Professor Proof, and the easiest way to play, as Jesus himself.
7 complete different worlds, with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral.
And don't forget that Gold Edition, where you can play the ultimate challenge, Devil's Doorstep.
This gory satirical adventure pulls no punches. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
So it looks like the chickens might be coming home to roost for Letitia James. We've been covering her corruption, which wasn't just about the Trump cases, but Indian Point Nuclear Power Plant, the American Irish Historical Society, her attack on the free speech of New York City firefighters, and the state eviction moratorium. But none are so juicy as what just happened. She has just been referred to the DOJ for prosecution over a mortgage scandal where she falsified records to get loans for a Virginia property at a much lower interest rate. You know, exactly what she prosecuted Trump for doing. We covered her laughable civil fraud trial, where insane Judge Arthur Engeron, the same man who posted a nudie pic to his alumni newsletter, said that Trump overinflated the value of his Mar-a-Lago home, which he said was only worth $18 million. When you can't even build a Walmart for $18 million these days. So she got a mortgage on a property in Norfolk, Virginia. She claimed that the property was her primary residence, which means she got a lower interest rate because banks always charge a higher interest rate on additional residences. The idea is that you're incentivized not to lose your home because you live there, and so you're likely to pay the mortgage, but that incentive doesn't exist on additional residences. But the problem is, as New York Attorney General, she's required to have her primary residence in New York. She also said she lived there with her husband, but the man she put down as her husband was actually her father? Ugh. She also misrepresented her 5-unit residence in Brooklyn as only being 4 units because the kind of loan she was getting only applies to properties with 4 units or less. More than 4, and it must be considered a multifamily dwelling, which, for similar reasons, results in a higher interest rate. The referral said, quote, based on media reports, Ms. Letitia James has, in multiple instances, falsified bank accounts and property records to acquire government-backed assistance and loans and more favorable loan terms. This has potentially included 1. Falsifying residence status for a Norfolk, Virginia-based home in order to secure a lower mortgage rate, and 2. Misrepresenting property descriptions to meet stringent requirements for government-backed loans and government assistance. The referral came from the director of the U.S. Federal Housing Finance Agency, the regulator of Fannie Mae, Freddie Mac, and the Federal Home Loan Banks. As you see, they take it very seriously when people misrepresent mortgages who aren't them. Ironically, she's trying to take advantage of the same incentives they put in after the 2008 financial crisis to make sure that lower-income borrowers could have lower house payments. James, by the way, has a net worth of $2.7 million. Criminal charges could include wire fraud, mail fraud, bank fraud, and false statements to a financial institution, and others. The documents showing her malfeasance are attached to the PDF file linked in the show notes. Legal scholar Jonathan Turley said,
Well, obviously, the irony is perfectly crushing. This is a person who prosecuted Trump for everything short of ripping a label off a mattress. And among the charges that were brought in New York, in not just the civil but the criminal case, was making false or misleading statements to financial institutions.
And this is using a very straightforward application of the law. In the Trump case, she had to twist herself up in knots to make all of these new and novel readings of the law to make it say something other than its plain language. But this is just the plain language.
The Supreme Court just stated earlier in March, in a case called Thompson, that they want to see knowing false statements under sections like 1014, not just misleading statements. These are misleading statements. Either it's your principal residence or it's not.
Or it's not.
Either you're married to your father or he's your father.
When asked for a response, her office said, quote, Attorney General James is focused every single day on protecting New Yorkers, especially as this administration weaponizes the federal government against the rule of law and the Constitution. She will not be intimidated by bullies, no matter who they are. I don't think you need me to make a snarky comment to that. It pretty much snarks itself. Trump posted to Truth Social, Letitia James, a totally corrupt politician, should resign from her position as New York State Attorney General immediately. Everyone is trying to make New York great again, and it can never be done with this wacky crook in office. Here's a question. How did this get past the appraiser? Is there even more corruption going on there? A different question. If she's declared her primary residence to be in Virginia, does that mean she's no longer qualified to be the New York AG and has to step down? Well, as she herself repeatedly said, no one is above the law. That was basically her mantra when she was suing Trump. But it's just the old Nazi tactic. Accuse your opposition of what you yourself are doing. Zig Heil, Commandant James! If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. And now from our They Just Won't Learn department, the latest in government attacks on privacy, encryption, and our right to be secure in our persons, houses, papers, and effects. Florida has just passed a law mandating encryption backdoors. You want to know how bad it is? It's called social media use by minors. They might as well have called it the Save Cute Puppies Act. And they're not hiding it behind their usual floofy language. The language of the bill says it is, quote, requiring social media platforms to disable certain encryption features for a specified purpose. A social media platform shall disable end-to-end encryption or other data encryption features that restrict the accessibility of messages so that a minor's parent or legal guardian may view all messages and law enforcement may view messages relevant to a felony criminal investigation involving minors. Which basically means turn off encryption for all minors all the time, which, as we've covered over and over again, would make them less safe online. Encryption is just as important for children as it is for the rest of us, maybe even more so. They aren't savvy enough to do the things knowledgeable adults can to protect themselves from hackers. And more than that, how is a minor supposed to reach out to people on social media if they have a parent that's abusing them if they know that parent can read their messages at any time? Your reminder that minors are statistically in far greater danger from family members and real-world acquaintances than they are from online connections. So not only does this destroy privacy, not only does this make them less safe, it's demanding the impossible. Remember our coverage of the Salt Typhoon attack? That major breach of U.S. telecoms by hackers affiliated with the Chinese government? That took advantage of the very same backdoors law enforcement insisted they put into their systems? Once again, there is absolutely no way to provide a backdoor that only lets the good guys in. A door once opened can be entered by anyone. And it also goes for whomever the minor is speaking to, because a lot of it is them speaking with their parents and teachers. They deserve the same kind of privacy as they do for everything else. And once again, the claim that law enforcement needs this kind of backdoor access just doesn't hold water. First off, we've seen plenty of times where criminals communicate in the clear and it still flummoxes investigators. Remember the Boston Marathon bombing? And second, there's no such thing as end-to-end encryption that makes it inaccessible to someone with physical access to the device. End-to-end encryption only protects from eavesdropping between the ends, not on the ends themselves. Social media sites are perfectly capable of using content-oblivious methods to provide necessary information to law enforcement, including detecting unsafe activity and online abuse, as well as user reports. And when combined, these are quite effective at detecting hate speech, harassment, self-harm, trafficking, grooming, and enticement. What isn't effective is encryption backdoors. There hasn't been a single study confirming that law enforcement can get anything from backdoors that they couldn't get much more effectively some other way. And those other techniques don't include the massive harm to minors that breaking their encryption does. This law amends HB 3, which still hasn't been implemented since it's being sued for being horrendously unconstitutional. But again, they're without excuse. They know this is unconstitutional. They know it won't help minors. They know it'll put us all at risk. And they don't care. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now it's time to pre-cultivate this week's biggest Bogon emitter. It's really strange the hill so many people on the left want to die on. We're giving it to the news media, but also so many people on the socials just have to pretend that Kilmer Arbrego Garcia is all sorts of things that he's not. An American citizen, a loving father, a productive law-abiding member of society. Whatever you think about the immigration issue, this is not the guy you want to hitch your wagon to. If you take the position that there should be no deportations at all whatsoever, well, that's a perfectly okay position to take, but don't make up crap or pass along lies. So let's look at these facts and how he isn't what the news media, AOC, people on Bluesky, and so many others are saying. Journalist Andy No posted a fairly good summary of it, pointing out, quote, Vanessa Vasquez, the Maryland wife of deported suspected gang terrorist Kilmar Abrego Garcia, either lied to the court when she petitioned for a domestic violence protective order against him, or she is lying now on the GoFundMe, claiming he is an excellent father and spouse. So far, she's raised almost $240,000, which, I'll be honest, I don't have a problem with. If idiots have decided that your husband is a saint who was horrendously wronged, and you decide to get as much as you can from it, well, a fool and his money and all that. But as far as that goes, I'll choose to believe her court testimony. If nothing else, going the other way would be accusing her of perjury. Twice, she sought and received protective orders against Garcia, successfully showing to the court that he's a dangerous, violent man. She also acknowledged that she only has one child with Garcia, whereas now the claim is that all 3 of her children are his. We'll go over the deets and drop the receipts, but just to summarize, Garcia was ordered to vacate the family home, cease all contact with Vasquez, and stay away from her and her mother's property. Custody of their one child was given solely to Vasquez. If you're wondering what Garcia's defense was, well, he didn't have one. He didn't show up to court. That's in addition to the other times he failed to appear for traffic offenses, which figured into the deportation decision. We now have her handwritten statement that was filed in a Maryland district court in 2021. She claimed, November 2020, hit me with his boot. August 2020, hit me in the eye, leaving me a purple eye. And the 2021 account is even worse. Quote, he got angry, and the baby started to cry because he was putting pressure on him. My immediate reaction was to push him off of us, and he then punched, scratched me on my left eye, leaving me bleeding. Later that day, quote, he ripped my shorts and shirt off, and I ran to the bathroom. He ran behind me, grabbed me by my arm. I have marks on my left arm as well. She reported that she had to call an Uber to leave with her kids because she was scared of him and was afraid to be close to him. She had photos and videos to back it up. The protective order says that the above-named respondent shall not abuse, threaten to abuse, and or harass the petitioner and others to be protected. That the above-named respondent shall not contact the protected parties by any means. Wow! So this is a no-contact order, not just a restraining order. Can't even call her on the phone. Now let's get into the MS-13 issue. This starts in 2019 with the interview sheet from the Prince George's County Police Department. It began with a detective, whose name was redacted. I know, funny name for a detective, who investigated 4 individuals for loitering. Quote, Detective Redacted immediately recognized Christian Hernandez Romero, aka Bimbo, as a member of the MS-13 Sailors Clique. He has an extensive criminal history for multiple assault, concealing dangerous weapon, burglary, and many other criminal offenses. He has also been found guilty of gang participation. Officers know Hernandez Romero to be an active MS-13 gang member with the Sailors Clique with the rank of Observacion and moniker of Bimbo. Officers also interview Jose Guillermo Dominguez. During the interview, officers observe tattoos of skulls covering their eyes, ears, and mouth. Officers know these kinds of tattoos are indicative of the Hispanic gang culture. He also had a tattoo of a devil on his left leg, which officers know only higher-ranking MS-13 gang members are allowed to get a tattoo with the horns. This represents power within MS-13. Officers made contact with a past, proven, and reliable source of information who advised Jose Guillermo Dominguez is an active MS-13 gang member with the Sailors Clique, the rank of Chequeo, with the moniker Maniaco. So whatever Chequeo is, it's a high rank. Got it. Now to our boy, quote, Officers then interviewed Kilmar Armando Abrego Garcia. Officers contacted a past, proven, and reliable source of information who advised Kilmar Armando Abrego Garcia is an active member of MS-13 with the Westerns Clique. The confidential source further advised that he has the rank of Chequeo with the moniker of Chele. Wow, he even has that really high rank of Chequeo. By the way, I skipped a bit about the clothing because the court didn't give it much weight. But lest you think they're just saying willy-nilly that they're just saying all these guys are MS-13, we've got one more dude, quote. Officers interview Hassan Josue Ramirez Herrera. During the interview, officers were unable to determine his gang affiliation. He was sent on his way without further incident. So this is where DHS steps in with their record of deportable and inadmissible alien. Quote, upon arrival, officers met with Detective Redacted, and he stated that a subject later identified as Abrego Garcia, Kilmer Armando, and Dominguez Jose Guillermo was detained in connection to a murder investigation. The subjects freely admitted being citizens and national of El Salvador by birth and that they were present in the United States illegally. The subjects were not in possession of any immigration documents that would allow them to be in or remain in the United States legally. Now listen to this. Abrego Garcia claims to be in good health. Abrego Garcia is not claiming fear of returning to his country. Oh, really? Quote, per Prince George's County Police Gang Unit, Abrego Garcia was a member of the Mara Salvatrucha MS-13 gang, Chequeo from the Western Clique, a transnational criminal street gang. This information was provided by Redacted, who has provided truthful, accurate information in the past. Abrego Garcia has gang affiliation, and subject states that he has no information about gangs or human and drug smuggling. Now what happened next? Quote, Abrego Garcia was advised of his right to speak with a consular officer of his native country of El Salvador, which he declined. Abrego Garcia is claiming fear of returning to his home country of El Salvador. Ah, changed the story there. Okay, so let's get to the ruling of the Immigration Court in April of 2019. They ruled, respondent failed to meet his burden of demonstrating that his release from custody would not pose a danger to others, as the evidence shows that he is a verified member of MS-13. The determination that the respondent is a gang member appears to be trustworthy and is supported by other evidence in the record. Although the court is reluctant to give evidentiary weight to the respondent's clothing as an indication of gang affiliation, the fact that a past, proven, and reliable source of information verified the respondent's gang membership, rank, and gang name is sufficient to support that the respondent is a gang member, and the respondent has failed to present evidence to rebut that assertion. The court further held that no bond was appropriate in order to ensure the appearance at future hearings, as he had not met his burden of showing that he would not be a flight risk. Although the respondent stated that he intends to file for asylum, his eligibility appears limited to withholding of removal and protection under the Convention Against Torture due to his failure to file an application within 1 year of his arrival in the United States. Those forms of relief are limited and contain standards that are difficult to meet. In addition, the record evidence shows that the respondent has a history of failing to appear for proceedings pertaining to his traffic violations. He asserted that he did not receive notice of these proceedings, but in his written statement, he admitted that he remembers receiving citations that he chose not to follow up on. The respondent's lack of diligence in following up on his traffic court cases indicates that he cannot be trusted to appear in immigration court. Wait a minute. I thought the news media said he never had due process. That sounds like a whole lot of due process to me. And there's even more because he had an appeal. That December, the appeals court found, we adopt and affirm the immigration judge's danger ruling. Notwithstanding the respondent's challenges, the immigration judge appropriately considered allegations of gang affiliation against the respondent in determining that he has not demonstrated that he is not a danger to property or persons. They then determined that this made the flight risk determination moot because this alone is enough to order deportation. Remember, he had claimed that he was afraid to go back home because a rival gang had threatened him over, of all things, his mother's pupusa business, a claim he went years without making and only brought up at the last minute to avoid deportation. The court had ordered him removable anywhere except El Salvador, but that was mooted both by the 2022 elimination of the 18th Street Gang and his revealed ties to MS-13, which is now designated a foreign terrorist organization. 2 different judges found he was a member of MS-13, and that finding remains undisputed. I mean, how much more could you want in the way of facts? You want to argue he shouldn't have been deported or should have been deported to a different country? Go for it. But while you are entitled to your own opinion, as this podcast has always maintained, you are not entitled to your own facts. Argue honestly or don't argue at all. So all of that gives the news media another biggest Bogon emitter. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins. And now let's over-exacerbationalize this week's Idiot Extraordinaire. Over the past weeks, we've been covering the problem of district court judges getting way beyond their station and making policy decisions that properly belong to the executive branch, that go beyond the parties in their case and that go beyond their districts to apply to the entire country. As Josh Blackman of the Volokh Conspiracy said, a district court judge is the closest thing to being a god. This is to show that the problem goes way beyond the cases we've covered in the D.C. District Court. In this case, it's the Fifth Circuit that had to step in with a writ of mandamus to stop the out-of-control district judge. Quick summary. In 2012, some death row inmates filed suit against Louisiana's lethal injection protocol. This was dismissed as moot in 2022 because the state wasn't doing those anymore. In 2024, the state introduced a new method, nitrogen hypoxia. Instead of opening a new case, they filed to reopen the dismissed case under the same judge. And the district judge allowed them to do that, even though new legal challenges must be addressed de novo in a new court through fresh litigation. The circuit had to smack that down. In case that sounds like nitpicking, it isn't. This goes straight to that same separation of powers argument. Hear it from the concurring opinion of Judge James Ho. This is not the first time our court has had to step in because the district court abused its powers. When the district court exceeds its limited role under our Constitution and violates our founders' commitment to self-government and popular sovereignty, it threatens the credibility of the federal judiciary and demands the active and aggressive intervention of the appellate courts. The judiciary has an important role in our constitutional republic, but it's a limited one. Judges don't write the law, nor do judges execute the law. As Americans, we believe that we should be governed by the people, not by judges with life tenure. Our founders didn't fight a revolutionary war to replace one king in royal garb with hundreds of kings in judicial robes. The American people don't believe in judicial independence so that judges can be imperial. The people believe in judicial independence so that judges will be impartial. If we lose that trust, that will be fatal to the rule of law, and it will be entirely our fault. If that sounds like a lot of boister for such a small case, as he says, this is just a final straw, the culmination of district judges doing this a lot and the appellate courts not stopping it. Our dissenting colleague asks, what's the rush? Even assuming that the district court erred, the dissent contends that there's no need for immediate relief, just let things play out. But that's cold comfort to the millions of voters who took the time to participate in the democratic process, only to see their legitimate efforts unlawfully undone by a single district judge. And that's what appellate courts need to stop. Quote, the Supreme Court did just that last week in Trump v. JGG. There, as here, a district court presumed to seize control over a case of profound public interest that it had no lawful business deciding, because it belonged in another court. So the Supreme Court intervened and took the case away from the district court. Like our dissenting colleague here, the dissenting justices in JGG urged delay. The Supreme Court rejected the dissent's plea for delay. The majority understood that waiting for an appeal in the ordinary course would inadequately protect the government from the indignity of litigating in the wrong proceeding, not to mention unduly delay the expressed will of the people. I most certainly concur. When a district judge acts hastily, yet appellate courts are told not to rush in, that's not a plea for judicial sobriety. It's a recipe for district judge supremacy. As Blackman wrote, in case after case, federal district court judges have issued a series of non-appealable orders, whether styled as administrative stays or temporary restraining orders. Courts of appeals have then declined to disturb these rulings, finding that TROs can only be challenged through mandamus and administrative stays are unappealable altogether. At that point, the federal government is forced to run to the Supreme Court seeking emergency relief. And what has the Supreme Court done? They have kicked the issue back down to the lower court, hoping that someone else makes the tough decisions. Who is running the show here? I think we are witnessing an inversion of Article 3. The Supreme Court is no longer supreme. Rather, the federal government is now subject to inferior court supremacy. Lower court judges are now confident they can issue any order they wish against the executive branch, and the Supreme Court will not stop them. This is the judiciary run amok. This isn't just a libertarian point. Everyone should be against the concentration of power, no matter where it is, no matter in what form. As this very issue shows, government cannot be trusted, and even when you have checks and balances, government cannot be trusted to check or balance anything. That's why all of this must be opposed at every point, including when the judiciary does it, no matter how much you hate the executive. Otherwise, you're not a person of principle. You're a partisan. So all of that makes district court judges this week's Idiot Extraordinaire. Well, that wraps up this You Know the Italian Court? What better place to court Italians edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord, Patreon, or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Lord Acton. I cannot accept your canon that we are to judge Pope and King unlike other men, with a favorable presumption that they do no wrong. If there is any presumption, it is the other way against holders of power. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.